Yes.
All right. So, hi, welcome. I'm Cang, attorney here out in Riverside County. This session is called Conflict Management Practices Post-Pandemic, Creating Compliance with Distressed Owners, a balancing approach. And for those that don't know me, they made me do this presentation because I'm pretty zen, pretty calm. And I sort of have a whisper when it comes to conflict resolution between homeowners and boards, even between boards and themselves and directors. So, um, and this last year that we've been going through, been quite stressful and a lot of emotions, mentally, physically, and for all of us involved and for your communities as well. So the sort of idea now is we're post-pandemic, we're heading out of the pandemic, and there's all kinds of issues and things that might come up as we come out of this pandemic. So how do we sort of figure these out and resolve some of these issues and problems and questions and disputes that we might have with owners moving out from this pandemic? So that's the sort of idea and theory with this. And hopefully by this afternoon, you guys are pros at these type of meetings now. In the last year, this is all I've been doing with these Zoom meetings, so I'm pretty well equipped. But let's just get started. Okay, let's see, make sure my slide works. So this is like the Super Bowl of presentations. There's a bunch of commercials. We have to thank our sponsors. Pro Landscaping is one of them there. Of course, Associate Your Property Management. And these are some of the other sponsors here that they make me go through. But, and there's me. So a little bit about myself. I've been an HOA attorney for about 15 years now. It's been a long time. Don't let the youthful appearance fool you. But I've been doing this for a long time. My only clients are homeowners associations. So I've been representing associations from inception to dissolution and everything in between. People, pets, parking, construction defect, pipes, pee, poop, all the pee problems that afflict and plague a homeowner association. That's what I do with, and anything else and everything in between. I'm the guy that they send into the courtroom. That's why I wear all the fancy suits, even when I'm in the comfort of my own home. And I'm the guy that they send into the boardroom as well. So from the boardroom to the courtroom, from anything and in between, what homeowner associations represent and deal with, I do. So that's me in a nutshell. Father of 3 daughters here in Riverside County, married my high school sweetheart. And that's my life in a nutshell. So with that, I think let's move on to the presentation. Here's the outline. Let me see if I can. First, let's just generally speak about the pandemic and HOAs. And there were some other presentations earlier today concerning the pandemic and what associations go through. Did anybody go to one of those presentations? Sort of, I don't want to repeat some of the things that you guys have already learned, but I'll sort of give you a brief general overview on the pandemic and how it impacted associations, what the attorneys were saying, what the industry was doing during that time. And then this sort of idea of there's 2 approaches now that we're heading out of the pandemic. And this is what this presentation is going to be discussing, these 2 approaches. One is a hard approach. The second is a soft approach, right? And I'll get into that specifically, but under the hard approach, it's what you think about what lawyers do. We enforce the law. We enforce the governing documents. And what you guys as directors and managers, you do as well, the enforcement side, right? The things that you were doing even before the pandemic. But what I want you to take from this presentation is thinking about it more of a balanced approach, this idea of the soft approach. And under the soft approach, it's a little bit more touchy-feely, a little bit more nuanced. It's communicating, it's listening, it's thinking about sort of creative solutions. Now, this presentation is specific to the post-pandemic, but it's something you can utilize even moving forward, and hopefully you were utilizing even before the pandemic. And so this sort of idea of this balancing approach. And what I've always taught my boards and managers is that there's a hard skill and there's a soft skill with this industry, right? The hard skill is the enforcement, the laws, the governing documents, and there's a soft skill, which is dealing with people. And in order to be successful, both as a board and as a manager, as an attorney, as an HOAs, I think you have to learn to balance those 2 approaches. And this is idea and this theory, this presentation, as we're moving post-pandemic, is that similar sort of theory and philosophy, and even more so of a balancing approach, because how politicized and how divided this country was during the pandemic, and some of those things are still going to impact your communities even moving forward as we come out of the pandemic. So that sort of idea, and behind this entire presentation, what you want to get out of it is that sort of dual approach when it comes to dealing with these solutions and dealing with distressed homeowners through this pandemic. So with that, I will sort of get into the beginning part of it, which is the pandemic and homeowners associations and what you guys were going through and what the industry was going through. So what's interesting, when this all started in March of 2020, and as California shut down, and there was the stay-at-home orders, and the calls that we were getting as attorneys was, what do we do? Do we shut down the pool? How do we have meetings? And the truth of the matter was, us attorneys we had no specific laws to govern the pandemic, right? It's not like when it shut down in March of 2020 or even April or even June, it's not like the legislator came out and enacted a bunch of new laws for homeowner associations to deal with pandemic, right? The state, health agencies, courts were all dealing with this on their own way. So there was no sort of, hey, let's have a meeting, let's get legislators to Sacramento and figure out how HOAs should deal with this. That was none of that. So there were no laws or guidelines specific to HOAs in the pandemic. So what did we as HOA lawyers do? We had to follow the same guidelines. We had to follow the same standards and the same things that were being imposed by the state on gyms, on restaurants, on workplaces. And because there was nothing specific to homeowner association industries, the attorneys had to turn to, well, what's the state telling restaurants? What is the state telling gyms? What is the state telling businesses? And we had to pull from those guidelines and then sort of morph them into specifics of how should homeowner associations utilize these same guidelines. And throughout the pandemic, it changed, it morphed. Nothing was ever stagnant. The CDC came out with different guidelines, the state came out with different guidelines, and us attorneys were trying to keep up with that of what the state, the federal government, and the CDC was imposing as guidelines on how to deal with the pandemic and all these situations, and taking that and then trying to apply it to all these homeowner associations and to our clients. And our clients are unique in themselves. You had condominiums, you had single family homes, you had communities with multiple pools, some with no pools, you had some with elevators, no elevators, all these different type of communities, all these different changing, morphing guidelines from the state and the county and the cities and the federal government and the CDC. It was just a hodgepodge of things that we hope we were getting right as we were advising our clients. And imagine if I admit to you that us attorneys were halfway confused throughout this process. Imagine homeowners, imagine management companies, imagine boards, in trying to figure out, how do we run a community when everything's shut down? How do we hold board meetings when everything's shut down? And then now trying to deal with running a community, running your household. You had kids, figuring out what to do with school and online learning, all very complicated things. And truth be told, for a lot of people and a lot of communities, running the association sort of fell down by the wayside, right? Or following specific laws and guidance concerning board meetings or how to do things sort of went out the window. In truth, throughout the pandemic, most homeowner associations were violating the law by having online meetings without a physical location, right? That's required by the law, but it sort of went out the window because you had to make do and try to cope with the circumstances at the time, given the same guidelines and rules that were just being applied to restaurants and gyms and other public facilities, and using that for your homeowner associations. So now we fast forward to the fall, and all of a sudden there's new guidelines. There's a tier system that became a little bit more specific, and that we're still kind of in right now, right? And the state's going to reopen on June 15th is the plan. But how it looks now is that we are just following this tier system. So here's the tier system, right? And Riverside County is currently in the orange, and we might be moving into the yellow pretty soon. LA County, Orange County are in the yellow. And what that means for homeowners associations, because there isn't anything on this tier system that lists out homeowners associations or common area pool, right? Nothing on the tier system is specifically about homeowners associations. So again, what does the attorney have to do? We have to get creative and make things up. No, we look at what could apply. And for the most part, it's these gyms and fitness centers for you guys, or the hotel and lodgings, right? We sort of figure out what category is most applicable to the homeowner association and then apply it and give advice on how you go about taking these guidelines and applying it to your community. So if we look at this, if we're in the orange tier now, for fitness centers, for indoor pools, those can open with modifications, 25% capacity, right? Indoor pools can open, spas would still be closed. And same thing with the gyms, that 25% capacity right now. Now that might change in a couple of weeks. That might change by June where there's no capacity limit and we'll be dealing with other things such as mask and possibly social distancing. So for you guys that don't know, the idea come June 15th is that we wouldn't have a tier system anymore and that the state would remove these capacity limitations as guidelines. And the one guideline that they would still impose is mask. The social distancing would no longer be recommended, no longer needed, because the capacity limitations would be removed, right? But then you still have the mask requirements. And again, these are state guidelines. So then if the board or the homeowner association says, well, we're going to follow the state guidelines and we're going to require people to wear masks, or hypothetically speaking, even right now, some of you guys who are implementing 25% capacities or whatever limited capacities of trying to enforce that, of trying to tell the homeowners, hey, we reach capacity, you can't come in, or putting reservation policies or however your community might be going about doing this, some of your communities might still be closed, right? Some communities just didn't want to deal with the cumbersomeness or didn't have the staff to actually enforce these guidelines. It was too difficult. So they're just going to remain closed until the state fully opens up. So it's been sort of a huge mixed bag on all different communities and associations and how they've been dealing with the COVID. So that's the broad picture of just the guidelines, right? Nothing specific to homeowner association. We still had to just utilize the same tools we had as attorneys and follow the state guidelines and implement those guidelines as best we could to the homeowners associations that we represented. And I will tell you some stories now that I'm getting, or some calls that I'm getting, is for the communities that have implemented some of these policies. It's the enforcement side. How do we enforce this? How do we go about telling people to wear masks? What about the ones that don't want to wear masks? What about the ones that don't want to social distance? What about the ones that are upset? What are the ones, a lot of emotions, and then they've been all this pent up demand. These people want to go use their pool. Now you're telling me I can't use this pool unless I wear a mask, and they're saying it's outdoors. They say it doesn't spread outdoors. I don't need to wear this because I'm outdoors. And then a couple of weeks ago, the CDC said you didn't have to wear a mask if you were vaccinated, right? So then how do you enforce that? How do you know the person that's not wearing a mask is actually vaccinated or not vaccinated? Can you keep them out of the pool area until they prove to you that they're vaccinated or not vaccinated, right? These are some of the questions we field as attorneys. And I'll admit to you, there's no clear guidance or no clear answer because there's no clear directive when it comes to the homeowners associations. So think about it when you go to a restaurant as well, right? And some restaurants will ask you to wear your mask when you get up and you're not eating and go to the restroom. Some people flaunt that directive or request. Some people just show up without masks. They say, I'm going to eat. And does the restaurant kick them out? The restaurant still wants their business, right? So this is sort of things that the businesses are dealing with their customers, and you guys as boards and homeowner associations are going to deal with. So when the conflict arises, then what do? How do you manage it, right? That's the sort of idea here of this, what we're going to get into. And again, homeowner associations, we're dealing with the same uncertainty as everyone else, as the restaurant owner, as the landlord, as the gym owner, right? How do you deal with this? If you're going to implement a mask system and people say, I'm not going to wear my mask, or say, I don't need to wear my mask because I'm vaccinated. And you have some board members or some management companies who say, no, we have to enforce this. These are state guidelines. We need to do this or we're going to get fined. We're breaking the law, right? So now you have this sort of tension between homeowners who think that these restrictions are done. We're done. COVID is done. I'm going to go living my life. And you cannot tell me that I cannot come to this pool if I do not have a mask, right? So that's the sort of thing we're going to talk about. Same legal tools. Again, no new laws came out to help us attorneys guide you guys. All we were dealing with the same state guidelines. So what do we do after the pandemic? How do we go about it? So with that, what you're going to think about is there's no pandemic at all. Because when it comes to enforcement, it's the same idea. You have the same tools as you did before the pandemic and during the pandemic. Your tools have not changed. Right? So then when it comes to this sort of idea of a hard approach, you still have the law and you still have your governing documents. Again, the law hasn't changed. Your governing documents haven't changed. Some of you might have enacted emergency rules or rules specific to COVID, right? To shut down your pool or to have emergency board meetings or however you conducted yourselves during the pandemic. But the enforcement side of it, that hasn't changed. The law hasn't changed on how one goes about enforcing these governing documents, even if you adopted rules specific to COVID at that time. Right? So it's the same sort of idea. If somebody's breaking your rules or policies that you adopted, you go through the same process, the same due process under the law now. You send out your notice, you ask them to come to a hearing, you potentially impose fines, you potentially suspend their use of the common area privileges. So same tools, before the pandemic, during the pandemic, after the pandemic, same enforcement procedures. The law didn't change. The law did not do away with the normal due process that is afforded to every homeowner if you're going to enforce the rules against them. So the same person who was violating the parking rule and you had to send a notice and then you had a fine and you had to go through that process of disciplining them. Now, if you're adopting rules concerning COVID, and let's say you have a mask rule, or let's say you have a capacity rule at your gym and the homeowners are violating it and you say, what do we do? You think that you do the same as you did with other rule enforcement before. Oh, right? That has not changed. That process, those requirements have not changed. They are now just being applied to a new situation concerning COVID and the requirements and the state guidelines of COVID, assuming you have now adopted those guidelines for your community, right? And so I should clarify that there was no mandatory requirement that homeowner associations sort of adopt these guidelines. In the thousands of communities that we represented, we were not aware of any community that got fined during COVID for not enforcing the social distancing or not enforcing the mask. I've had presentations with healthcare departments of counties, and those agencies say they didn't go around finding people. It just wasn't, they didn't have the manpower for it. The outbreak was such a concern that it wasn't, wasn't something that they did. And just for your edification, violation of a health regulation is actually a misdemeanor under California Penal Code. So they could have gone in and they could have issued fines and misdemeanors to some of these people who were, let's say, not enforcing some of the masks or social distancings or the capacity limitations. County health departments had that authority. Now, they weren't exercising that authority because there was a lot going on, and I'm not aware of them ever exercising that authority with respect specifically to homeowners associations. That being said, if your community has adopted specific guidelines as to COVID, social distance, or anything that the state has provided, your enforcement mechanisms are the same as with any other rules and restrictions, same process, all right? So then when it comes to the actual law, same procedures are still provided in the law. Now, courts were backed up for months because courts were closed, but the mechanism, if the fines and the hearings and the notices don't get the owner's attention, then you could obviously take it and escalate it to a potential lawsuit. And those procedures are still the same. Alternative dispute resolution, right? You still have IDR, which is just a meeting between a director and an owner to talk about the issues and the violation and try to resolve it. You still have ADR, mediation and arbitration. Those procedures are still the same, right? So any escalation of a dispute, any escalation of a violation, even as it is applied to COVID, The legal requirements before you take action against an owner are the same. The legal requirements of the pre-litigation, before you sue somebody, you have an IDR, you have an ADR, you try to resolve it short of running to the courthouse, they're still the same. That never changed. That has not changed, has not been amended for anything specific or particular to COVID-19 or the pandemic, and it won't change post-pandemic. These procedures have been around for a long time. There's no indication they will change specifically when it comes to post-pandemic and after we're done with COVID, right? So that's the hard approach. That's the sort of how you enforce all your rules and regulations before, during, and after the pandemic. But I want you to think about it a little bit differently when it comes to now specifically COVID and the soft approach. And this soft approach, for me, the first thing is communication. Communicating with your community. And the relationship between the board and its community is best when it's open and when there's communication back and forth. That's the idea of the open board meeting. That's the idea of open forums. That shouldn't change, and it actually should be augmented and improved as we move into the post-pandemic time, right? It's even more important now for boards to listen to their community. And I mentioned to you, we represent thousands, and they're all different. And I'm not one to ever sit here and say how you should deal with your community on specific things. I guide you on the law, but you guys know your community better than I ever will because I don't live there, right? I'm just a lawyer. But my advice and my suggestion is on the soft approach is the communication between the board and its members and its residents, whether that's in the form of more written communications, emails, town halls, whatever it is, letting the membership know what the board is thinking, what it's going through, how it's sort of navigating this new post-pandemic COVID-19 world helps. And admit that it's uncertain. Admit that it's going to change and it might change. Admit that the board is trying to figure it out, and admit that not everybody's going to be happy with how the post-pandemic sort of guidelines and rules are in place. And have that communication, have that discussion with your community at the get-go. For those of you who are doing the tier system and having capacity limitations, don't just say it's 25% are people allowed in the pool. Give a number, right? Don't just say it's going to be only this amount, this percentage in the gym. Like, spell it out for them and tell them how that's going to work. Or if you don't know how it's going to work, ask ideas from your community and your residents, right? Work with them and get the input from them in order to help you make better decisions, and decisions that hopefully aren't controversial, and a decision that most of the community is okay with, but at least they're involved in that process and that thinking, right? Because again, no laws, no specific guidelines specific to homeowners associations. So you as a board have this sort of discretion and openness to figure it out, but figure it out with the input of your community, all right? And then with that part of the communication first and foremost is listening, right? And listen to your members, listen to what they have to say, listen to their concerns, and ask them questions. What I'm getting from a lot of communities and residents is they're upset because the board is just saying, bam, this is how it's going to be. Here's what we're doing. And a lot of boards who have always taken the hard approach, meaning the hard enforcement approach, continue to take that approach without involving their membership and without asking the members what they want or what they think is good for the community, involving them. Right. So boards, there's a lot of them who are approaching it from, oh, this is just a parking violation issue. This is like a landscape violation issue or an architectural issue violation. Right. And all they're thinking about is taking that hard approach. The law is on our side. We're the board. We have all the authority. We can do this. And that's when, if you continue with that approach, without a softer approach, without this duality in mind, that's when the conflict happens. So with that, you ask the questions, you listen to your community. See what they want, see what they're open to. A lot of communities are doing surveys, doing online surveys or these monkey surveys to figure out what the community wants. And I've suggested that to some. Do you want the pool open? When do you want the pool open? Are you okay if the pool's open one Monday through Sunday or whatever the case may be? And then there's also a frankness that you should have with them, right? You should tell them, like, we don't have the resources to keep the pool open and monitor a 25% capacity, right? We don't have the funds for that, or we don't have the resources for that. So here's how we're thinking about approaching it so that we are still able to keep it open during certain time periods, and with the resources we have in order to enforce or to ensure the capacity limitations, right? So all those things that, you can discuss with your community as you're thinking them out, ask them what they want. So that's the sort of broad picture idea when it comes to trying to figure out the post-pandemic. But when it comes to specific situations, and I had one where a mother took her kids to the pool and she refused to wear the mask, right? So the management official shows up and says, ma'am, you have to wear your mask. And she says, well, I can't. My children are autistic. And that manager calls me right away and she says, I don't think she's being honest. And, she sort of chastised her. And I said, well, no, you got to listen to her out. You got to talk through that process with her and don't just take a hard approach and say you have to wear a mask without considering her position, right? So asking the questions, communicating, and then from that, you try to resolve it, right? And through the communication on specific situations where you're trying to enforce a new rule and there's pushback, the communication is to resolve a problem. It's not to defend your actions or not to defend your authority or your position as the board, right? In a post-pandemic world, when you're taking a soft approach, it's listening to get answers, to figure things out, and then to try to resolve a matter, not to defend. And easily when people are coming at us or when we're having an argument, all we want to do is defend our position sometimes, right? I'm a lawyer, that's what I do, I defend. But the craft of being a lawyer is also figuring out what the other side is saying, right? What the problem is and figuring out a solution. So for you guys as well, you communicate, you listen to try to resolve problems, not to defend your authority and your power. That's a given. But for nowadays, think about that in the context of trying to resolve problems. And then understanding context and situation, right? Again, we are in a post-pandemic world. People are pent up. There's a lot of demand out there for use of the common area facilities to get back to normal. And so the new norm is not going to be the same as the old norm, right? So understanding the context of situations, for example, the pool situation with the woman and her two children, think about that in context. Two children, they've been pent up. They've probably been doing homeschooling for months. And they just want to use the pool. So you taking a hard approach and wanting to fine them, wanting to kick them out right away just because they're not wearing a mask, take the situation in context and try to resolve the matter or diffuse the matter instead of just taking a hard approach and say, you have to follow our rules or you got to get out. All right. Sometimes listening, sometimes getting down their names, getting down their information and having a dialogue with them to try to resolve it is a much better way to go about it. And the one size does not fit all, right? Just because you have the same tools and the same laws that you had before doesn't mean that they work and apply in every single situation anymore. So it changes, it's different. You have to adapt to every situation and your new environment. And one thing to look at is the fair housing interactive process. Before COVID-19, when somebody made a request for a disability or an accommodation, the law provided this sort of interactive process. It's already built into the fair housing laws. Some of those procedures and guidelines would be pretty useful in a post-pandemic world, even when it doesn't come to disabilities or reasonable accommodation, right? So for example, if somebody was needed a pool lift because of a disability, under the fair housing laws, the association and that resident would have to engage in this interactive process to figure out if they're really disabled in order to utilize the pool lift, who pays for the pool lift, things of that nature. It's what they call an interactive process to figure out a resolution. It's under the Fair Housing for Disabilities. That type of procedure uses sort of a hard and a soft approach as well. And it was already built into the law. And it's something that we could probably utilize and think about for post-pandemic situations to resolve problems, right? So hang on, there's one last slide or one last discussion as I have about 10 more minutes here on this presentation. If I can find my clicker. Okay. Oh, and the last thing, be reasonable. So if you talk to any lawyer and they've ever been in a courtroom or they ever argued, judges are always like, be reasonable, right? Judges love that, this idea of reasonableness, which can be gray, but being reasonable is not always taking that hard approach or putting the hammer down on any rule violation. It's finding that sort of middle ground. And for boards, you don't always get the answer you want. You don't always get the resolution that you might think that you want, but you got to be reasonable and think about it as a community as a whole, right? If it ever gets into court, that's what judges always sort of look at. Was the association reasonable in their approach? So we always keep that in mind, that reasonableness. So why take a balancing approach, right? It's built into the law. And I mentioned earlier about the whole due process of notices, fines, and then even IDR and ADR. Those are legal procedures, but if you think about it, they're legal procedures that seek a balancing approach. They're legal procedures that try to diffuse a situation before the parties have to sue each other. But within the law itself is the idea of balancing. Don't just run to the courthouse and sue just because you're upset with a homeowner. Think about trying to mitigate the situation through an IDR, through an ADR. So built within the law is the idea that you have to balance it, you have to be reasonable before you run and sue each other. That is already built into the laws that govern homeowner associations. And that approach is not going to change. And I've already gone through 3 lawsuits during COVID concerning things that happened or actions that boards took during COVID. And the association lost in all 3 of those cases because they didn't take a reasonable approach. They took this sort of old idea approach that we are right, we have all the authority, we're going to do it this way because we're the association, and it sort of bit them in the butt because they just didn't have that balancing approach. And judges now, they've gone through this COVID, they've seen how things are happening in the landlord-tenant situation, and now they're seeing it in the homeowner association situation. So think about that it's already built into the law. And the approach of the soft and the balancing, it mitigates and avoids conflict. And I mentioned earlier about the communication. So if somebody comes in and they're upset and they're arguing with you as a board, and the first thing you want to do is defend your position or defend your authority, there's a fight right there, right? You guys are already butting heads. But if the approach is to sit back and listen, ask questions, and think about a way to resolve a problem rather than trying to defend your position or defend your rule. So if you guys implemented a capacity rule or a mask rule or social distancing rule and somebody's coming in to challenge it and ask and upset about it, the first instinct should not be to defend that. Oh, that is the state's requirement. Well, we're just following the state guidelines. We're just doing this. Rather, listen to what their situation is. Listen to why they are upset, why they believe they should not be wearing masks, and then ask them the questions. And then sit back and then think about how do we come up with a creative solution or a solution with respect to this homeowner or a solution that we might implement for the entire community, right? Be malleable, be flexible, think about it in a way that you adapt. This entire year has been ebbs and flow on how rules and regulation guidelines have changed. You as a board post-pandemic, think about that as well. You're going to have to adapt and change as the situation and context evolves and changes as well. And so taking that sort of soft approach helps mitigate and avoids further conflict rather than butting heads. And you're taking this approach because you guys are the leaders of your community. You set the example, right? So if you take a sort of idea of we're going to balance it, we're going to try to figure this out and be reasonable, it spreads. It's that sort of philosophy and that sort of approach. If the board takes that, if they're seeing that the board is communicating with its community, getting feedback from its community, not just taking the hard approach, it bleeds out into the community, right? So you guys as leaders set the sort of tone for the entire community and how you go about enforcing the COVID rules or adopting COVID rules or guidelines. And the tone you take at board meetings, the approach you take at your board meetings, the tone you take within any communication, whether it's written or oral throughout the community, that sets it for the entire community, right? So what you guys do when you're sitting at your board meetings and you're thinking about how we're going to communicate this, how we're going to do this, it impacts your community. So as leaders, think about that and think about the tone you're setting and how you're going about both adopting and enforcing new guidelines and restrictions post-pandemic. Right? Again, situations will evolve, things will change. You guys have to adapt. We all have adapted in this last year, and we all have evolved and changed, hopefully for the better. And hopefully you guys think about that post-pandemic as well, that this is going to evolve. It might change next month. It might change in 2 months. We might have another surge. There might be another variant out there. Who knows, right? Because we didn't know how we were going to get here from 6 months ago, right? December, January, it looked pretty uncertain, looked pretty gloom, but we're better now. But you always got to be prepared that things might always change, and you guys will always have to adapt and evolve as boards and directors as well. And so taking that sort of balancing approach and listening to your community will help you adapt. And so with that, that's my spiel. I hope you guys got something out of it. I know it was pretty broad picture, 3,000 level feet, but I think the sort of idea for you guys is it's not the same. It won't be the same, and sort of adapt, balancing it out. The people, personality, skills, the soft skills that comes with being a successful board are just as important, even more important than the hard skills and the law and all the things that you have at your disposal as a board on the legal side. And if you do that, then you won't have to call me ever again to deal with your legal problems, hopefully, to my own detriment. But in it, I will leave it out for any questions. Did I see a chat? I didn't see. I should have opened up my chat window. There we go. Okay, so no, are there any chats? All right, guys. So if you guys had any questions, you're welcome to shout them out. You're welcome to throw it into the chat box here, or find me somewhere on the internet. I'm somewhere around. So with that, thank you. Been a great group, and that session is ended.
Thank you,
Thanks,
Cang.
everybody.
Good job, Cang. Appreciate it.